SJC-09265, Commonwealth v. Jason Robinson.
Okay, Attorney Scapicchio.
Good morning, Your Honors. May it please the Court. My name is Rosemary Scapicchio, and I represent Jason Robinson. I'd like to divide my time today, if it's agreeable to the Court. I'd like to spend 10 minutes on the direct appeal and 10 minutes on the sentencing issue, if I could. So I'm going to try to keep track of the time and ask for permission to switch over after 10 minutes. So the first issue I'd like to bring up on the direct appeal is that the evidence here was constitutionally insufficient to establish Robinson was guilty of felony murder, where there was no evidence that Robinson knew the shooter was armed. In this case, the evidence suggests that this particular victim was picked because he was passive, that he wouldn't put up a fight. The evidence is that Mr. Robinson, with his co-defendant, arrived at 89 Faneuil Street. They then, each one of them, stood beside the victim and walked into what was the bottom floor of 89 Faneuil Street. No gun displayed at all. The evidence then is that about 5 minutes passes, and that Mr. Robinson is then seen coming from 75 Faneuil Street, which is almost diagonally across from and up from where 89 Faneuil Street is. A completely different building, a completely different parking lot that he's coming from. His co-defendant comes directly out of 89 Faneuil Street, gets into the vehicle in the alleyway that was there at 89 Faneuil, and then Ms. Tate gets in the car, and ultimately Mr. Robinson gets in the car. And although there is evidence that Mr. Robinson is counting money, there still is no evidence that he was even there when the gun was fired, or that he knew that his co-defendant had a gun. In this case, the evidence is that the co-defendant turns and hands a gun to him, and then subsequent to that, they drive to a park and hide the gun underneath a truck. And subsequent to that, there is a conversation that takes place the day after, where the co-defendant summonses everyone to a park down by Watertown, the Arsenal Mall, and they have a conversation. And it's in that conversation that Tate has with the co-defendant in this case, that he confesses to what he says happened. And his version of what happens is that he was telling the victim to keep his arms up. The victim was saying, please, please. He got nervous and he shot him. Doesn't say that Robinson was there, doesn't say that Robinson played any role, and indicates that it was an accident. In other words, he got nervous and he did it. So based on those facts, I'm suggesting that a conviction of Mr. Robinson, and he was only found guilty of felony murder as a joint venture, not as a principal in this case. So the law requires him to know that his co-defendant had a gun. And what I've just gone through in terms of the evidence suggests that he didn't know. Now, I know this court just decided Commonwealth versus Eagles, a joint venture case as well with respect to felony murder, and I think this case is distinguishable. And it's distinguishable because there's no evidence that Mr. Robinson saw the victim get shot. There's no evidence that Mr. Robinson didn't look shocked. There's no evidence one way or the other as to whether or not he did. But I would suggest even if this court gets to that point where you're evaluating the after conduct, which I would consider to be the accessory after the fact conduct, but if this court evaluates Eagles under the way that I think it should, all of the things that this court said the defendant in Eagles should do, you have to take into consideration, I think, that you have a 19-year-old kid, 19-year-old kid who was just involved in something that he may not have known what the gravity of it was in the beginning.
Mr. Scapicchio, could you use that outline that you just laid out for us and incorporate it into the co-conspirator statements and
Sure.
the conversation with Tate?
Sure. So the co-conspirator conversations, there are a few. First, the co-defendant makes a statement to the police in which he puts himself with Robinson during the day of the homicide. And he lies about his whereabouts in the homicide, clearly. And then he has a conversation with Tate where he tells Tate, essentially, this is what happened. First of all, he says, he's murked, I got my body for the summer, which indicates that he has his body, not my client, but it's certainly relevant to my client. But the most egregious, I think, statements that came in against Mr. Robinson is this idea that his co-defendant confessed to Tate. He said that even though Robinson and The co-defendant led the victim into the hallway. The co-defendant, kept telling the victim to keep his hands up because they didn't want to, he kept on reaching for the door. And at some point he says he got nervous and he shot him in the head. And during that conversation, he's the one who places Robinson at the scene of the crime. He's the one who says Robinson is leading him into the building, and he places him there. Whether or not he's there during the shooting or not, those statements came in without any limited instruction, and they weren't in furtherance of any conspiracy. Tate wasn't a co-conspirator to a homicide. She was only charged with an accessory after the fact. And Tate was the third party that the confession was made to, which in this case I would suggest that statements of joint ventures to third party are not admissible under these circumstances. And then statements made after the joint venture is over. And I would suggest that once they leave the alleyway and they go and they hide the gun, then it's done. What's happening from there is the co-defendant's direction, not Mr. Robinson's direction. Mr. Robinson isn't saying, everybody come and let's talk about what happened. Mr. Robinson isn't the one that's making any efforts to conceal anything at that point. That's all the co-defendant. And that statement that came in against Mr. Robinson over his trial attorney's objection is what would require this court, I think, to reverse the conviction. How do you let someone make a statement that is in essence a confession, that he was there, that he did this with my client, and not give my client his Sixth Amendment right to confront and cross-examine that witness?
Assuming, as you suggested, it's not in furtherance.
Assuming, well, I think that the points as to why it's not in furtherance in this case is because that meeting was not generated by Jason Robinson. I think it would be a completely different story if the co-defendant and Robinson were calling people saying, let's meet at the park at Arsenal Mall. Let's do that right now because we've got to talk about what we're doing. But this was all the co-defendant and Tate. And in fact, when this statement was being made, Mr. Robinson is 20 feet away talking to some other girl. He's not there when this co-defendant is confessing. He's not there to say, wait, no, that's not how it happened. He's not even hearing this conversation. So he can't even react to it at all. Yet it comes in at trial as a link in the chain that ultimately convicted Mr. Robinson. And I would suggest that because the conversation at the Arsenal Mall was not part of a continuing joint venture at that point, not with respect to Mr. Robinson. It may have been a part of his co-defendant's efforts to talk to his girlfriend because she was insisting on telling him the truth about what happened. That's what she was doing. I want to know the truth. You got to tell me the truth. And so they're sitting on some swings, having this conversation between themselves about what's happening. And Mr. Robinson is 20 feet away, has no idea that conversation is taking place. And then at trial, that conversation comes in against him as if he was there when that conversation took place. He had no opportunity to confront and cross-examine the co-defendant. He had no opportunity to put that statement in the context in which it was. And that's why it violates the Sixth Amendment. That's why, and under these circumstances, the case should be reversed. Now, I notice I'm running out of time. If there are no more questions on the direct appeal, I'm going to move on to the sentencing issue. Now, what we're asking the court to do in sentencing is to put a categorical ban on life without the possibility of parole sentences for emerging adults, because individual sentencing hearings will result in unfair impacts on people of color and does not comport with the evolving standards of decency.
Counsel, what is the upper limit on an emerging adult?
20, well, it's up to 21. So 20 years, 364 days. That's essentially what it is. We asked, and that's what the expert said.
So it's 21, and the basis of that is what? Why did they pick 21?
The basis of that, Your Honor, I can tell you is that prior to, when this court decided Duchenko, essentially it got it right, okay? And what happened after Miller and Duchenko, what was happening up to that point is all of the studies were either under 18 or over 18, because 18 was the demarcation point at that time. Once Miller got decided, the studies started to break out those categories of people, 18 to 21, 21 to 25, 26 to 30, and they did extensive studies. And I would suggest that the studies that were done post-Miller, post-Diachenko, are much more robust than the studies that this court had when they decided Diachenko. And so there's no question, there's no expert that's going to ever say that the people who are in the 18 to 21 category, when they're in hot cognition, act more like the 16 and 17-year-olds than they do the 24 to 25-year-olds.
What about cold cognition?
Say that again?
Sorry, what about cold cognition in the particularity of the juvenile in front of the judge?
Well, that's an argument that the Commonwealth makes in terms of cold cognition. And the problem with cold cognition is Dr. Steinberg, who testified for us in front of Judge Ullman, indicated that hot cognition could come on so fast that it's almost impossible to determine when you're in cold cognition and when you're in hot cognition.
What about the Commonwealth's expert?
The Commonwealth's expert didn't disagree with that. They didn't disagree with the fact that hot cognition could come on quickly. What they're saying is that there's a possibility in some fairy tale world that somebody between 18 and 21 could commit a crime in cold cognition. And what they're looking at to determine that is the elements of the atrocity of the crime, not the person. And that's not what we're looking at when we're looking at life without the possibility of parole. We're looking at the person, not the crime. So if you want to look at the crime and all of the atrocities the Commonwealth's going to put forward about he could have planned this and he bought a gun and he went to school and all of those things, you're talking about the crime. And that's not what we're talking about here. When this court decided Diachenko, we were talking about the individual defendant, not the crime. Because we're going to lose every time if we're talking about the crime. There's no way for a defendant to win on a homicide
They
case
might
when you
not
talk
be
about the
guilty.
crime.
What if they're not guilty?
What if you're not? Oh, no, I'm saying after conviction. After conviction. No, I didn't mean that at all. So what I'm trying to say in this case is that this court is in a unique position from every other court in every other state. Because you got it correct in Diachenko, you now have not only did this court do the right thing, but you now have 10 years of data from the parole board to look at whether or not you're right. 10 years of data. And that data tells you something extraordinary, in my opinion.
Ms. Scapicchio, before we go into that, I think there's a preliminary question. Diachenko cites the Cepalonis. Cepalonis provides the three-part test for cruel or unusual punishment under the Declaration of Rights. And Diachenko gets cited along with Cepalonis in other cases. Why is it that we're just assuming that the three-part test of Cepalonis doesn't apply?
But I think it's because of the emerging information that we have now, Judge. I think that the information that we have regarding emerging adults is much different than we had when Diachenko was decided. I think that all of the studies, as an international study, the Cohen study, all of those studies suggest that that age category, 18 to 21, in hot cognition, act more like 16-year-olds. So what do we do with them?
Assume that's true.
Right.
Just for the purpose of my question, because we have to distinguish the United States Supreme Court, which in Roper has made clear that it's a category, that 21 is a category.
Yes.
That's a social norm that's being adopted, and they're only analyzing younger than a certain age.
Yes.
You know that from Roper. Why do we assume from the language of Diachenko, where the discussion is about juveniles, that the science is necessarily the entire analysis?
It's not.
Okay.
It's the science and then the evolving standards of decency, both combined together. So it's not just the science, Your Honor. It's science plus. And in this case, what I was trying to get to is the evolving standards of decency. We have this data set that no other state has. And when you look at the data set from the parole board that we have, it will tell you that of all of the Diachenko people who went before the parole board, 74% of them were paroled. 74%, which means 26% were not paroled. They were not deemed fit to return to society. And that's a job, I would suggest, that the parole board is much more filled with information than a sentencing judge. I think when you talk about the remedy, and you talk about Diachenko versus Miller, I think that the Diachenko remedy, asking a judge,
You're talking about the 15-year passage of time?
Yes.
Or 20-year passage of time?
sometimes 15, sometimes 20,
Right,
sometimes
not-
25,
Not
depending.
that, because judges, I take somewhat issue with the amici. Judges have to make individual calls all the time. Then
Right, but they
that
can't
is
make-
suited than the proba.
But-
But what we're talking about is what this person looks like as an adult
Right.
when they're 30 or so.
Right, but what we've learned is the individual judges, trial judges, can't make a reliable determination. They can make a determination, certainly they can, they're a judge. But it's not reliable, and up to 87% of the time, they get it wrong. 87%.
It's only unreliable because of the passage of time.
It's unreliable because you can't make that determination when someone's brain isn't fully formed. You can't make that determination as to whether or not they are capable of redemption. What the parole board has in front of it is 15 years of data. Did he educate himself, or did he or she educate himself? Were they able to hold down a job? Were they able to comply with the rules? Were they able to stay disciplinary report free? Have they engaged in activity that would make them safe to be back out in society? Have they redeemed themselves?
Well, is there any validity to doing a brain scan at the time of parole, when that comes up, to see has the brain in fact developed?
Well, what the doctors who testified at the hearings have said is a brain scan at that point might be too late, because the time period
Well,
between...
no, I mean, suppose you did one in the beginning and then you do one later.
You do one at the time of the crime, are you talking about?
Yeah.
And then do another one at the time of parole? I don't know what it would show at the time of parole. My suggestion, based on what the experts said, is that the passage of time would make it difficult to make those fMRIs effective 10, 15 years later. It wouldn't be, because it's not, I think that when we look at the brain science, when we look at the studies, there's no way for any specific expert to stand before a judge and say, this defendant is going to reoffend.
How is this any different than normal aging and wisdom?
It's different from aging and wisdom because this class of individuals don't have a fully formed brain. Their brain is still maturing. It's the same reasons why this court decided Diachenko.
Is that true for all juveniles or all people of emerging adult? Would that be any brain we looked at?
From 18 to 21?
Would they all look the
say.
same?
I don't know that you can say individually. That's the problem, Your Honor, is that no one can look at an individual defendant and say, this one's going to reoffend and that one's
I
not.
understand that, but my question is, this finding with regard to the 18 to 21-year-old brain, that applies regardless whether they're charged with an offense or they committed an offense.
That's correct.
Okay.
That's correct.
How do we take into account the variability that was discussed in the hearings?
Well, the variability as to
Offenders.
Well, I think the problem with the variability as to offenders, I think you have to acknowledge race when you're talking about the variability of offenders. And when you start looking at the race, these are what the statistics are. 77% of juvenile offenders serving life without the possibility of parole are black or brown. 77%. That should shock us all. But that's the standard. And black youths are serving sentences that are 16 times higher than white youths. And we have to do something about that implicit bias. And how that happens, if you have individual sentencing, the way the Commonwealth is saying under Miller, you're going to have disparate sentencing according to the judge. Everybody understands that. And what happens is juvenile offenders that are black and brown have longer records, have more interactions with the police, don't acclimate to prison the same way that other people do. And so they're going to have a worse record when you're making that determination. And they're going to end up serving life sentences without the possibility of parole. And that's exactly what happened after Miller.
I understand your position about the Suffolk DA's office's brief. I get it. I'd like you to talk about the Essex DA's office amicus brief for a minute, where the point that they're making, and this goes back to my initial question, is Diachenko is about juveniles. The United States Supreme Court is about juveniles. And the issue, there's a preliminary issue here, which is whether before 21 is a social norm age that relates to a legislative determination, or whether or not within, because I'm not sure why it doesn't apply, the Cepalonis three-part test, that science should be an aspect of the analysis post-21? That's the initial question. I don't get the Suffolk DA's office position.
You don't get their position?
I mean, I understand it, I just don't agree with it, for the reasons that you said. But I'd like to understand why 21 isn't a social norm like in Roper. Graham and other cases in the United States Supreme Court recognize that the difference between 20 and 364 days and 21, I mean, that's
But
not
when
the
the Supreme Court
difference.
made those determinations, they didn't have before them the robust record that we have. They didn't have before them the scientific evidence that we have now that suggests that that category of 18 to 21 is more, it acts,
Got Supreme Court cases that say we recognize that, I think it's Graham, this is
Right.
just a number.
but we're not supposed to, I mean, if we're talking about the constitutionality of someone serving a sentence under Article 26, if we're talking about whether or not that's unconstitutional, then why are we talking about whether or not the legislature should handle that? If it's unconstitutional, then it's up to this court. This court has to take that on.
I'm asking you about the if. I'm asking you about if Cephalonus applies, and you're trying to figure out what is the difference between 20 and 21, whether the choice of 21 is a legislative determination. And there's nothing in Danchenko that says we're looking at anyone post-21. That's the initial question.
Right, I don't think anyone's looking at anyone post-21.
Well,
But not now. That's the question.
Right, but
At what point, if I could ask my question, at some point, it does become a number. And I get that the emergent adult testimony in this case was centered on 18, because that was a remand, 18 to 21 or 18 to 20.
That's correct.
18 to 20, I think.
18 to 20. But anyway, when do you come in 3 years from now with the 22-year-old?
I will tell you that this soft science is no different than the hard science that we deal with. We deal with changes in DNA, we deal with changes in fingerprints, and when the science changes, the law changes. And that's
Excuse me,
exactly what's happening
can you-
here.
Can you
and
identify?
at some point, we're going to have to say it's a number, correct? Or do we
no, at
just,
some
or
point
we
it-
just have a roll-in hearing where we tie it to the brain science?
I think it's the brain science plus what is acceptable within the community. I think that.
That's the issue, is as Justice Lowy said, at some point, it does become social norms. That's why we get into,
But I don't know that.
Let me finish. We get into the questions of, alcohol purchase in military service, et cetera, right? At some point, it becomes a number. At some point, it becomes social norms. So what's to distinguish the 20-year-old from the 22-year-old?
Well, I think it's the science, it's a database that we have that distinguishes them. It's the robust set of data that we have, and it's looking at the way that society has moved. We've moved from 18-year-olds being able to drink to now it's 21-year-old. We've moved from 18-year-olds being able to purchase, not purchase alcohol, but 18-year-olds being able to do things in the past that they can't do now. So society is evolving. We're moving that number because society says 18 is too young to be able to make those determinations.
Counsel, isn't that because society and the societal norms are informed by the data that we're living? So it's not either or, it's both and.
That's exactly right. It's not just the science. And if I didn't make that clear, I will say again, it's not just the science in this case. It's the science plus what is.
what's the plus? Because the end of Diachenko is very focused on science. I'm just trying to make sure I understand what the plus is that you're referring to.
So I think in this case, when we talk about what's correct, it's the science plus the evolving standards of decency.
Okay,
That's it.
but there, we're ahead of the rest of the country, right?
Absolutely.
So there's only one other state, Washington, that's done what you're asking us to do, right?
That's correct.
So how do we analyze the plus factor if we're ahead of the curve? It goes against you, right?
No,
So
because
it
you
goes
have
for
the
you.
data set that nobody else has.
But the data set isn't the data set of the 25 people in Massachusetts. The data set is the science, which is everybody, right? It's
Right,
not,
it's the science that we have developed from the time of Miller and Diachenko. It's that robust area where there's international studies,
Right.
there's
Right. Now,
psychological
Counsel,
studies.
earlier you mentioned this was soft science. Can you explain the difference between soft science and hard science and how that might affect a Daubert hearing?
Sure, I think with respect to hard science, you're talking about things that you can actually see. If you put a DNA sample into a device and the data comes out, you might differ about what the data says, but it's a hard science. That's what it is.
True for the brain scan too?
I think, but it's not just the brain scan. It's the brain scan plus, all of these other areas, the psychological studies, the crime statistics that we have, all of them together. When you take the crime statistics, when you take the psychological studies, when you take the fMRIs and this new MRI data, it's all of it together. It's not one individual, and they all corroborate each other. The crime statistics corroborate what the psychological studies are saying. The psychological studies corroborate what the fMRI studies are saying. So it's these three branches of information all coming together to say the same thing, essentially. And the same thing, essentially, is that juveniles are different. They're amenable to rehabilitation, and we should treat them differently because the science says so and because the evolving standards of
Now,
decency
the
say so.
evolving standards and the emerging adults, do we have any evidence with regard to how they handle rehabilitation?
Well, I don't. I do not have any evidence right here as to how they handle rehabilitation.
Because you said the evidence showed a juvenile can be more easily
I was
rehabilitated.
talking about the people that got out with respect to Diachenko, the under 18 people.
Right.
So with respect to nobody.
So I want to know, does that same kind of reasoning apply to the 18 to
Well, I
20-year-old, or
think-
do we not know?
I don't think we know, but I think we can find out because I think that there are some people who were sentenced to second-degree murder who were in that category who got out and who have been doing well. I think if you look at the amicus brief from CPCS, they talked about all of these kids that were Diachenko kids that got out, and they did well, phenomenally well. There were only 3 of them that got sent back out of all of them that got out. So it's working. Treating people who have underdeveloped brains differently because they're not developed works. It gives them the opportunity to redeem themselves and to prove to a parole board, to 7 members of the parole board, that they're ready to enter society again. And that's not an easy task. Going before 7 members of the parole, we're not asking this court at all to open the doors and let anybody out. All we're asking you to do is make a categorical determination that life without the possibility of parole for this category of people is unconstitutional under Article 26, and it's because of the science and because of the evolving standards of decency. And again, I will say, this court got it right in Diachenko. The same arguments that the Commonwealth are making right now are arguments that they made before this court in Diachenko. And if you think about the impact of sending 203 cases back to trial judges, to now hire experts on both sides, hold hearings on both sides, try to make determinations from whatever you can in terms of the record at 6-part folders at each of these institutions. That's going to clog the system up forever. And what are you going to get? You're going to get exactly what you have right now, because you're still not going to be able to have.
Defense counsel's not always overly concerned about clogging the system, right? We've taken 1 million drug cases and, sent them back, right? So
Right.
that's really not a
but what
driving force, particularly for you, right?
What I'm saying, Judge, is that you're not going to have any more, the sentencing judge at that point is not going to have any more
I understand that
information
this
than he
may
has
be.
right now.
I understand this may be an impossible task for a sentencing judge, but we're not being driven by the number of.
I understand that. You're being driven by the Constitution. And Article 26 says if they're the same as Diachenko, you should treat them the same as Diachenko. And so now the decision is remedy. Do we do a Diachenko remedy or do we do a Miller remedy? And I think the Miller remedy leaves so much room for disparate treatment of the black and brown community that we can't do it. 77%? We can't let that be. We can't be in a society where it's okay that 77% of the people that are serving life without the possibility of parole for 18 to 21-year-olds are black and brown. There's something wrong with that statistic. And we know, because this court did a study, we know about the implicit bias that exists within the criminal justice system. We know about the overcriminalization of black and brown people in the community. We have to do something about that. And if we don't recognize it in this context, then many, many, many of those 203 men and women are going to spend the rest of their life in jail. If there are no more questions, I'd ask you to reverse Mr. Robinson's conviction and enter a finding of not guilty on the required finding. And if not, I would ask you to consider the categorical ban on life without the possibility of parole for that emerging adult 18 through 21. Thank you.
Okay, thank you. Attorney Linn.
Good morning, Your Honors. Paul Linn for the Commonwealth. With me is Special A.D.A. Cailin Campbell, who will be arguing the brain science issue. I will be addressing the issue of the direct appeal, the issues on direct appeal. I cannot emphasize enough, as I did in my brief in my 16L letter, that A.D.A. testified at trial that after he heard the gunshots, he saw the defendant and Anderson running away from 89 Faneuil Street, which is the murder scene, together. On cross-examination, he denied that he had actually seen them exiting the building, that is, coming out the door. But he said still, at that point, that he saw them right next to the building. So the evidence in the light most favorable to the Commonwealth is that Tate sees the defendant and Anderson leading the victim into the building. 5 minutes later, there's a gunshot. Seconds after that, Gauthier sees the defendant and Anderson running away from 89.
I'm sorry.
I'm sorry, Justice Gunn.
Does-
That still doesn't answer the question about whether or not he was aware that there was a gun there. So how can you connect those dots?
Correct.
Now you can say that everybody knows they had that conversation about they're going to rob this. He's docile. He's not going to essentially put up a fight. So we can get you with all of the robbery part, but how do we get the gun?
Well, the first thing that I would point out is that the jury did not have to believe Tate's testimony that she told anyone that Yazbek was docile. That's not the evidence in the light most favorable to the Commonwealth. That's self-serving, trying to make her look better than she was in this case. Because of course she's the mastermind of this. She's the one who put the plan together. Second, you're robbing a man in the city, in a housing project in the middle of the night. They try to choose a secluded location, but there's still that possibility that...
Do we have any cases that say that the circumstance?
Yes, that's Ferguson, which I cite in my brief. That's a case in which they robbed a drug dealer.
Right,
I mean, there were some questions, was the defendant or co-defendant who stabbed the drug dealer in the back? But that's when the court says, you can infer from the circumstances of a drug robbery that the defendant would know that the victim might resist and therefore someone might be armed. And of course, as I point out in my brief, certainly whether or not Tate said that the victim would be docile, that didn't stop Anderson from carrying a gun.
Yeah, but I guess that was my point, because we have this inference, and I'm familiar with Ferguson, but we have this inference, but it's rebutted perhaps by the introduction of the Tate evidence, that the victim's a docile person.
As I say, the jury can believe parts of a witness's testimony and disbelieve others. They absolutely, in the light most favorable to the Commonwealth, under the Lattimore standard, do not have to believe that testimony. The Commonwealth is not bound by that testimony on the Lattimore standard.
So what's the legal standard as far as the inference that someone is armed? If anybody is of fighting age or something, that you get the inference that they had to have a gun?
No, that's the starting point. You start with Ferguson and say the very fact that it's a robbery is some evidence. In some circumstances, legally sufficient evidence under Lattimore. Whether or not that's the case here is a close question, but then you get the evidence upon the evidence, which is the defendant stays with Anderson, runs away from the scene with Anderson, gets in the car, no reaction whatsoever. His reaction is he has this cell phone that Tate hasn't seen, he has this wallet, he's counting money in the wallet, he says $46, and he hands it to Anderson. Anderson says 46, because of course Tate also supposedly said that he was known to carry a lot of money. So now they have killed a man, and instead of saying, oh my God, you killed him, I didn't know you were going to kill him, the defendant says $46. That's his reaction to this whole thing. And certainly in Booth and Cailin Cruz, and most recently in Eagles, this court has said you can consider first of all, two things from that line of cases. The first is, under Massachusetts law, you do not necessarily have to know before the robbery that the defendant was armed, so long as you learn about it before the killing, or if there's no killing, if it's just a robbery, as long as you learn about it during the robbery and continue to participate. And you certainly can consider the things that the defendant did after the crime as evidence of what he was doing and thinking at the time of the crime. My sister is absolutely correct that you cannot convict the defendant based on what he did after the crime. That's accessory after the fact. But in Booth and Eagles and Cailin Cruz, the court makes it clear you certainly can consider that evidence of what the defendant said and did after the crime as evidence of what he was thinking and doing at the time, and thus convict him of armed robbery and felony murder based on that. And that's the evidence here in the light most favorable of the Commonwealth. He shows no surprise. He continues to participate. He runs away with the defendant, or excuse me, with the co-defendant. He's counting the money. He, by all indications, keeps the wallet. So he is still participating, an active participant in this joint venture, even after he learns beyond any reasonable doubt that the co-defendant Anderson was armed because he shot the victim. Turning to the joint venturer's statements, I would first emphasize that the Commonwealth did not offer these statements as adoptive admissions, which would require the defendant to be present and know the statements under circumstances in which he would be expected to deny it. Although I think we could have done that on the statements to Gauthier because he was standing right there. But we had offered these statements as statements of a joint venture during the commission of the joint venture. And I take issue with my sister's claim that the jury got no limiting instruction as soon as Tate started testifying about statements that Anderson had made. The judge instructed the jury that they could not consider these statements against the defendant unless they found that a joint venture existed and that these statements were were made in furtherance of the joint venture. And there's,
That a joint venture existed separate and distinct from the
yes,
state.
yes, there was also, yes, other, but of course here you have them plotting the murder together and getting people together. So there's certainly other evidence besides the statements that this joint venture exists. And certainly I think Robertson is the best case for the Commonwealth here. In Robertson, the statements are long, I mean not long after, but they're after the crime. They're after some of the co-defendants are arrested, and these are statements made among the co-defendants trying to figure out to get their stories straight while they're in jail. And most important, the defendant got away. The defendant isn't even there when the Robertson statements are made. And some of these statements are very incriminating. Thank God they didn't find the gun. If I ever get out of here, I'm gone. I'm off to Cape Verde. These are extremely incriminating statements, and they're still admissible because they're made in the course of trying to preserve this joint venture, trying to make it, conceal it even after the crime is finished. And that's exactly what you hear. You have an even better situation here because there's no doubt that the defendant is present, that these are still all the joint venture is getting together, even if he doesn't actually hear the statements while he's sitting on the swings with Heather Cody. He's still part of these meetings. He's still part of this effort to get together, and with Anderson trying to make sure that everyone keeps their stories straight and nobody goes to the police. And that's what he's trying to do. That's a joint venture. That's a statement in furtherance of the joint venture. And so these statements, and it's clear that from the case law that joint venture statements do not violate Crawford. They don't violate Bruton. Because you take your chances that your joint ventures are going to say something incriminating during the course of the crime.
Yeah, I understand. I didn't take Mr. Scapicchio's argument as saying that there's a confrontation clause issue or that these were adoptive admissions, or that she made the point that the defendant wasn't even there during the conversation. But really the point she was making was that at this point in time the conversation is concealing in furtherance between the co-defendant and Tate, and that's a different joint venture and different conspiracy that the defendant's not in. That's the real point of he's not there.
I think that's contrary to the law. I think Robertson is directly on point.
Oh, he doesn't have to be there. I understand he doesn't have to be there, 100%. What she's saying is that the discussion between Tate and the co-defendant was during and in furtherance of their concealed conspiracy and not having to do with her client.
I don't think that holds water, but I understand what you're saying, Your Honor. I see my time is winding down. Do you have any questions on this issue or any of the others?
We're all set.
Thank you very much, Your Honors.
Thank you. Okay, Attorney Cailin. Oh, sorry, Attorney Campbell.
Good morning, and may it please the court, Cailin Campbell appearing as the Special Assistant District Attorney on behalf of Suffolk County. I'd also like to acknowledge A.D.A. John Verner, who is the motion prosecutor in this case, who's also sitting at the second counsel table due to the number of us today. We ask you today to hold that a sentence of life without the possibility of parole is unconstitutional if mandatorily imposed, but constitutional for those 18, 19, and 20 after an individualized sentencing hearing.
I don't understand the middle ground.
Nor do I.
In the middle ground being that, what we said in Dachenko that our Article 26 remedy is categorical. The other ground would be what a lot of the rest of the country does and say it's a number, like Roper does, and it doesn't apply after juveniles. Why the middle ground?
Sure.
Other than it being something that we might bite on.
I don't just think it's something that you might bite on. I think if you look at, so we didn't come to this conclusion, I can assure you, because it's something that you might bite on. I think it's supported by the record, and I think it's supported by the law. And I think that if you look at the record and you look at the consensus, this case has been difficult at multiple points in litigation because I felt as if the Commonwealth and the defendant were speaking entirely different languages, even though we were looking at the same case law and listening to the same testimony and reading the same studies. I think if you look at the record and you look at individual testimony of the experts and you look at individual articles written by some of these experts, you could pick or choose parts of those to support any argument you could make. I think the far better and what this court should do is look to see where there is a consensus as to these experts and as to the articles and what you can draw from the consensus. And if you look at the consensus, and this comes through both the testimony and all of the articles that are part of this record, what emerges is that in this group of people, 18, 19 to 20, there is a consensus that brains are still developing, but the problem is that brains do not mature among age boundaries. Brains also do not mature uniformly. There is a very large variation in how brains reach maturity, and there is a very large maturation difference or how...
Would you support a Miller hearing then? Some of the science is 23 to 26-year-olds. Would you support a Miller hearing then for 26-year-olds?
Not to 26-year-olds. I think...
25?
Not 25.
22?
Not 22, although 22 is where I think I would end it, both based on the studies and the experts' testimony that brain maturation ends somewhere in an individual's 20s. But if you also look at the age crime curve, which all of the experts testified about, crime behaviors and impulse-seeking behaviors peak at 17 to 22, and then if you look at it, there's this precipitous drop-off. So at least there's corroboration that there's something amongst that age group.
But what's the poor trial judge going to do? So most of the science suggests that their brains are still maturing, right? So is the trial judge going to be doing brain scans? Is the trial judge going to be... I just don't understand how the trial judge is going to do this in any kind of way that's meaningful, consistent with what we said in Diachenko. Because Diachenko is like that's the Everest of all these cases at
Correct.
this point. It's the Article 26 determination of this court. Roper is a federal. We've provided more protection, and we've focused on the science in Diachenko pretty emphatically. So I just don't know how the trial judge can possibly do this consistent with Diachenko.
Correct, and I have a few responses to that. The first is I was struck by the ending of my sister's argument in which she said, if they're the same as Diachenko, then treat them the same as Diachenko. I don't think the record supports that they are the same as Diachenko.
Well, aren't they actually worse? I mean, in some sense, the sensation-seeking aspects of 18, 19, and 20-year-olds is actually worse than under 18. So I don't understand the Commonwealth's position.
See, again, I think that's just one aspect, and I think sensation-seeking in highly aroused states, yes, but not in other states, not in other emotional states or cognitive states. So again, that's where I think it's not the most useful thing to look at just portions of the record, because I think it could support any position that you would want to choose. But I think that...
going back to Justice Kafker's question is, how is the trial judge to do this individualized hearing when you can pick and choose? And
certainly, and I think, and this sort of dovetails with a question that Justice Lowy asked my sister. I think that there is a hyper focus, I would agree, in both of the briefs, as to Diachenko and as to the science. I think that's because that was the focus of the remand, but I don't think in a sentencing hearing that would be...
But isn't that the focus of Diachenko? I mean, Diachenko is driving, it's making us different from the rest of the country, right? I mean, we can't really sort of re-argue, I mean, you're not saying we're not going to follow Diachenko. That's what Diachenko does.
I'm not. I guess my response to that is sort of twofold. It's interesting because if you look at Diachenko, the language of Diachenko, specifically the irretrievably depraved language, that's relatively new language if you look at it in the context of the law. It first appears
I'm just looking at there are two paragraphs in Diachenko which seems to drive everything. The ones that being given current scientific research on adolescent brain, and it just goes from there. That's the driver of all of this, isn't it?
It is, and I think if you look at the record, there is a difference between those under 18 and those over 18. I think that's one.
Can I ask you one question on that? Is there any differentiation made in the studies between male subjects and female subjects?
There isn't, although there is, I think, one of the experts did testify that there would be a difference between males and females.
But we don't, were they just studying males?
They were just studying males. If you look at the studies in general, Justice Cypher, you asked a question as to why it was 18, 19, 20. It's actually interesting when you look at the studies, and critiques of this can be found in the original filing that the Commonwealth made under District Attorney Rollins. There is a critique of the studies because they tend to come from college students who are 18, 19, 20 years old, and they're not studying necessarily the influence of crime and what drives crime. They're studying more impulse control and sensation seeking.
But in justice, isn't there a bunch, these studies say that, the younger women mature faster than the younger men, don't they? Isn't there consensus in that?
Yes. Yes, there is.
I guess, putting aside that I really don't understand, considering Diachenko, why it wouldn't be a probative determination if, in fact, we're going to treat 21-year-olds, 18 to 20-year-olds the same. Mm-hmm. What I'm struggling with is Stepelonis was mentioned, referenced in Diachenko as the prong one. It's mentioned in Appellant, which is a murder case. What is it that has us looking at 18 to 20 as a category that's not a social norm category? Or when is it we've ever delineated before at this point in age? What Diachenko says is when it comes to children, this is the science.
Correct.
It's not addressing what happens when it's not science. And I get the remand, and I think it was an important remand, and this is important information to have, and it fits within the analysis for step one, Stepelonis. But I just don't understand how that's gone.
And I don't necessarily, I think if you were to put that analysis, if you were to adopt that analysis, and it's interesting because until you asked the question, I was sitting there, and then I went back and looked at my brief, and you're right. The focus is not on that Cephalonus test. The focus is largely on the science. I think it's because everyone was focused on Diachenko as the starting point, and then what the science shows. You know, it's an interesting preliminary question. I think there are similarities between those 18, 19, and 20 to those juveniles. I don't think that you can make the same broad conclusions. I don't think you can make the same conclusions, for example, in Miller, I think the specific language is that because these characteristics do not vary on the individual or the crime committed, that is why, in part, they're reaching that ruling. That same language is echoed in Diachenko, and in specifically in Diachenko and in Miller, they're talking about the inability of individuals, not only the brain science, but the inability of individuals below 18 to extricate themselves from the home environment or from the bad environments that they're in. I don't think, though those may be a factor that does apply somewhat to those 18, 19, 20. I don't think it applies with the same force to that group of people. So, you know, insofar as Diachenko was the starting point and the science was the focus of the remand, I don't necessarily think that it indicates that Cephalonus wouldn't apply.
Diachenko, which cited Cephalonus, always gets cited in the context of Cephalonus.
Correct. I see that I'm out of time, and I do have more time after the next argument, so I will wait until then to address some of these questions. Thank you.
Thank you.